Hey everybody, John Skiba here from the Consumer Warrior YouTube channel, live here on Thursday night, here to answer questions, go over topics, provide resources if you're dealing with serious debt issues. Again, my name is John Skiba. I am a bankruptcy and a consumer attorney in the state of Arizona and a founder of this Consumer Warrior YouTube channel. And what we do each and every Thursday night, at least most Thursday nights, is I come on here and we answer questions. Whether you're dealing with debt collection lawsuits, facing bankruptcy, wage garnishment, whatever it is, I hope to provide some, alleviate some of the stress by understanding that there are options and ways to deal with it. Like we do each and every Thursday night, we are sponsored by SoloSuit. SoloSuit is a great company that can help you with some resources and tools, particularly if you're looking at debt settlement or if you're looking to, if you need to respond to a debt collection lawsuit. They use technology and have some cool resources on there. Go ahead and check their link out. It's listed in the chat section over there on Facebook as well as on YouTube. And so that's how we do this also each and every week. If you have a question, put it in the comment section on Facebook or on the chat section here on YouTube, and I'll put it up on the screen and we'll talk about it. My weekly disclaimer. We got to always have the weekly disclaimer. While I am a licensed attorney in the state of Arizona, I'm not licensed anywhere else. And so you should take what you're hearing today as some guy just chatting away on YouTube, and that's about it. If you need actual legal advice, if you're in the state of Arizona, you can reach out to me. My information is scrolling there along the bottom. I'll also put a link in the chat section where you can actually set up an appointment to talk to me. If you're not in the state of Arizona, unfortunately, I'm not able to meet with you. I can't even do consultations. And so you'll need to find an attorney in your particular area. All right, man, we already have a lot of questions on here, so I want to jump on here. Rob was here nice and early. Got to get up over the thing here. Rob says, update on my case where the plaintiff filed a motion for summary judgment 11 days before trial. Even though I responded, they still won. Even objected to the 3 affidavits they submitted. So sorry to hear about that, Rob. And it kind of brings up a point. I always say that no matter how good, how strong the case is, no matter maybe like in a situation like this where the creditor did stuff that was against the rules, there's not a lot of certainty in courts. And particularly like Arizona has an interesting system where anything under 10 grand in dispute is dealt with our justice courts, and anything over that is dealt with our superior courts. The justice court system, many of the judges are not attorneys. They're not legally trained. They're elected. And so sometimes we can get into situations where they just have a different opinion on this than maybe like an attorney or a judge who, had gone to law school did. And so there's some unpredictability there. And so sometimes I'll say, settlement can be, a good definition of winning your case. Not every case needs to go to trial. Not every case should go to trial, and actually very few do. I can tell you in my law practice, we settle cases all the time to try to overcome and mitigate some of the risk that comes with trial. Trial's all or nothing. You're either going to win and owe zero, or you're going to go to trial and you're going to owe the full thing, maybe plus some attorney's fees. So that's where you got to be a little bit careful. All right, let's see what House on a Budget has to say. Just subscribe. Love all the info you share. Thank you for subscribing. We're up to about 65,000 subscribers. Appreciate everybody who has subscribed. And if you haven't, what are you doing? Go ahead and subscribe today. Do it. We live in Wisconsin and have a small claims debt trial next Wednesday, defending ourselves as it was identity theft. The videos have helped a lot. I appreciate that. And the identity theft, it's one of those things. What we got going on here? I've been working too hard today. I'm all disheveled. The identity theft is something, if there's an identity theft issue, bring it up often and constantly every chance you get. And the answer, trial, mediation, whatever it is, make sure you're bringing up the fact that there's an identity theft issue. Often I'll recommend filing a police report to show that there's identity theft. Make sure you bring that up and make sure that the court understands that. Because courts will, if they see that there's a legitimate identity theft issue here, a lot of times they'll make the situation work so it comes out to your benefit. All right, Joe said, I had a bank account levied about a year ago, but it was not enough to satisfy the judgment against me. Can Credigy do that again? And what is the process and how did they do that? I switched to the bank, but I'm afraid they'll empty this account once they find the new account. So how it works is when a creditor is able to levy on a bank account where they come in and they freeze the account, take the money out, they usually have to go through a process where they get a writ of garnishment. It's a writ just like they are if they're garnishing your wages, but they get the writ, they find out where you bank or where they think you bank, they serve it on the bank receives it, and they're required to freeze any account that you have with that particular bank. Okay, so they usually do it by name, social security number, whatever they have, and they'll freeze it. Now, bank accounts in many jurisdictions, there are exemptions that will protect a portion of those funds. So, for example, in Arizona right now, the exemption in one bank account is $5,000 per person, $10,000 for a married couple. So, but it's only in one account. So if you have a lot of accounts, and I don't know what, maybe it's just all these online accounts. I've noticed over the 20 plus years I've been doing this, people used to have like one or two accounts, and now we file bankruptcies and I see they have like 15 bank accounts. I'm not sure why. But so like in Arizona, the exemption is only for one account each, or you can stack your $10,000 exemptions in one account. So, but some states, that's a recent change in Arizona law. Arizona law used to be $300. So it really depends on what the law is in your particular state, if there's money that can be protected. But once they freeze those accounts, there's usually some period you have to respond to, as far as whether you actually owe the money or not, or the judgment's valid or not. But then the court will eventually enter an order that has them transfer those funds out of your account. So in a situation, Joe, like you're dealing with where they levied it, but there's still a balance out there, they can keep doing that. I can tell you, usually they don't know the balance. They can't call up the bank and the bank tell them, hey, Joe's got, $5,000 in the account right now. The banks can't do that. So they're usually doing somewhat blind when they send over their writ. But yeah, they can just keep doing that. They can do wage garnishments. They can kind of keep poking around until they get that balance paid. That's why it may be worth. That's what I'm saying. Sometimes you have to look at the win is really just getting them out of your life. And so getting some type of settlement in place, or even if it's some type of payment arrangement, could help you to move on so you don't have to have that stress. All right. House on a budget at a follow-up. What happens at a small claims trial when the defendant wins? We're the defendant and believe we will win. Will the debt be squashed if we win? So the way, like I was saying before, the trials are all or nothing. So if you prevail, and you got to remember, at trial, the plaintiff bears the burden of proof. So they've got to prove that you took out this loan, that you incurred these charges, and that you didn't pay it. Now, your identity theft is kind of like an affirmative defense. So the court will require you to provide some evidence of this. This is always a little bit difficult because you're kind of trying to prove a negative. Trying to prove that essentially you didn't do this. You didn't enter into this agreement. But if you can show, or through your testimony, you can say, look, this wasn't us. The address is wrong. These charges, I live in Arizona, but all the charges were in Iowa or whatever, something like that. You can provide that. The court will have to determine whether the plaintiff has met their burden of proof. Now, in a civil case, the burden of proof that a plaintiff has to establish is different than in a criminal case. We're used to hearing in criminal cases where, it's beyond a reasonable doubt. That's not the burden of proof in a civil case. It's a preponderance of evidence. It's 51%. The scales just tip a bit. If they can prove 51% that you do owe it and there's not a defense like identity theft, then they will win. But if you prevail and you're able to show that, they didn't prove their case, then as the defendant, there will be a judgment of dismissal. If you paid any court costs or attorney's fees, sometimes you can request those to be reimbursed. There would be a judgment of dismissal. And not only that, to answer your question, yes, the debt will go away. And what I tell people is you need to get an order from the court showing that you prevailed at trial. Because if they don't remove that from your credit report, that's something you could submit to the credit report saying, look, this was adjudicated by a court. We don't owe it. And that can help to get that squared away. All right. Dark Emperor says the trustee in my Chapter 7 case adjourned the 341 meeting due to not having all of the statements required. We already had the second meeting about a month ago. Will this delay my discharge date? So the 341 meeting, if you file a Chapter 7 bankruptcy, everybody has to go through what's called the meeting of the creditors. The short term is the 341 meeting. 341 that's the bankruptcy code section that states that this meeting has to occur where the trustee will meet with you. In Arizona now, they do it via Zoom. They put you under oath, and they're going to ask you a series of questions about if the information's accurate. They can ask you questions about assets, transaction, that kind of thing. So when it comes to that, if you show up and they don't have all the documents they need, they can continue it to a later date, which just sounds like they will here. And will it delay your discharge date? It can. It can delay your discharge. Usually the discharge is entered roughly 60 days after the meeting of creditors is concluded. And so if the trustee did not conclude your meeting of creditors at the first meeting and they continued it, once they conclude it, it's usually about 60, can be up to 90 days, just depends on how quickly the court processes. All right, let's see. Alberto says, live in Arizona, 14 months left before the statute of limitation applies on my $50,000 credit card debt. What should I do these next 14 months? Cross your fingers that they don't sue you. Because if they sue you within that 14 months, then, they're going to still be able to pursue it. There's really, if you're just trying to wait out the statute of limitations, really, there's not a whole lot to do. Because really it's just a matter of time. If the time goes by, they don't sue you, then you're good. If it doesn't go by, if they do file the suit, then you're going to have to defend it and try to deal with it that way. So, all right, I wanted to go into a couple questions that we had on the channel that I thought were pretty good. This person says, this is in relation to debt collection lawsuits. It says, what if the debt collector cannot find the defendant to serve? What will happen to the case? I have read that in some states, the case will be dismissed. So it is true, and it also brings up a question I get quite a bit. A lot of people will get a copy of the complaint and it has a date stamped on it from the court, and then but it's been more than the time that's allowed in the summons to respond to it, so they're stressed out. Usually what happens is the creditor is required to file the complaint or the petition, whatever they call in your state, and then they have a certain amount of time to actually serve you with the documents. It's usually 90 to 120 days, depending on your state. And so you're going to see the date earlier, and the time to respond as provided in your summons, that starts ticking along once they serve you, once they actually drop it off. Now, if they can't find you, routinely I see this in Arizona. If they don't serve within that time period, the court will dismiss it, but they dismiss it without prejudice, meaning that it can be refiled again if they do that. So with something like that, if they can't find you, you got to be careful because they can go and get what's called an alternative service order. The alternative service order states that they can serve you through like posting on your door. They could mail it to you, sometimes even email it to you. So you got to really keep an eye out for it. This person said, can anybody file bankruptcy or do I need assets? All I own is my vehicle, which is paid off. I don't own a home. I'm not married. I don't have a job. So yes, anybody can file bankruptcy. You do have to qualify to file a Chapter 7 bankruptcy. There's a means test. I can get the numbers here and just kind of give you an idea. It varies from state to state and it changes periodically. And so, for example, in Arizona right now, an individual has to make less than $68,000 a year in order to be able to qualify for a Chapter 7 bankruptcy. If you make more than that, you may be able to file a different chapter, like a Chapter 13. But if you want to file a Chapter 7, which is overwhelmingly what people file, it's about $68,000. And again, I'm recording this video in December of 2024. These numbers change regularly. So if you're listening to this later on, just be aware of that. And then it goes up, like for a household of 2, it's $83,000 roughly. Household of 3, $99,000 a year. Household of 4, $110,000. And like on my little sheet here, all the way up to a family of 8 could make up to $149,000 a year and still qualify for a Chapter 7. Now you don't need assets. The idea behind a Chapter 7 bankruptcy is they're going to see if you have any assets that are not exempt that they can sell and distribute to your creditors. And in your situation, you're saying you don't have any assets. Your vehicle is paid for. And so that would be considered an asset. So you would need to make sure that that it's within the exemptions or the protections of your particular state. For example, in the state of Arizona, the exemptions on a vehicle, it's $15,000 of equity. So in a situation like this, where the vehicle is paid for, as long as it's worth $15,000 or less, you can keep it, no problem. If it's something, let's say someone had a vehicle and it was, still had $10,000 owed on it, but it was worth 20, you're still okay because there's 10,000 owed. It's worth 20. So you have about 10,000 of equity. You're within that $15,000 of equity. So you'd be fine there. So real quick, yeah, you could file as long as you qualify for it. And you don't need to have assets. In fact, if you don't have assets, it makes the whole process a lot more smooth. All right. This person says, so if I file for Chapter 7, I won't lose my home if it has a homestead exemption. That's what scares me the most. I'm current on my mortgage. So yes, as long as you're continuing to make the payment, the thing to think about with secured debts that have collateral or property attached to them, as long as you keep making those payments and the equity in your home or your car, like I was just talking about before, is not above the exemption in your particular state, you're going to be fine. So in Arizona, the homestead exemption protects $414,000 of equity. It gets adjusted every January, so that's about to change. I think it's going to go up to like 425-ish. As long as you don't have more than $414,000 of equity in your home, you're going to be fine as long as you keep making the payment on it. That's going to be the key there. And then this person said, what if the summons, so we're talking about debt collection lawsuits again, what if the summons doesn't say anything about responding? Mine just says show up or it'll be defaulted. This is a good point. So this is different than like what I do here in Arizona. Some jurisdictions, particularly small claims courts, instead of filing an answer, they just set an immediate hearing date. You see this a lot with like eviction hearings, where they don't really expect a written response. You just get served with the complaint and it's like, hey, show up 3 weeks from now on this date and at this time. I would talk to an attorney in your particular state if it says that, but 100% show up. Don't not show up. I always say 95% of these cases is just showing up, because most people don't. Most people don't file responses. Most people don't show up, and then you lose automatically. They don't even have to prove their case, and then you just lose. So it's something that you've got to, just show up, and you'll be fine. All right. Joe says, will my house and car insurance go up if I have declared bankruptcy? A lot of it's going to depend just on your insurance company. They do look at credit. Usually they only look at credit though when you're actually pulling out the claims. If that's not true, somebody can tell us in the comments that deals with insurance. But I'm just going from my experience when I get a new quote, that often it's they pull my credit then, and they'll base the premiums on that. So I don't believe so. So if it's credit worthiness, it's going to show up there. Surprisingly, for most people, your credit score actually starts to go up relatively soon. Within 6 to 12 months after filing, you're going to see that it starts creeping up again. And usually within 2 years, it's fully recovered. All right. I think that's all the questions we had for today. So we can wrap it up there. We've been going about 20 minutes. That's a pretty good stretch. If you do have questions, I spent about a half an hour tonight just going through comments in this section, trying to respond to them. Go ahead and go to the channel. If you haven't subscribed, please go ahead and do it. And if you need some tools out there for debt settlement, filing an answer, go ahead and check out Solo Suit. They have some pretty cool resources there that can help you out. And with that, we will catch you next week.